Hello, this is attorney Jeremy Hogan, and today we're going to be talking about the kaboom lawsuit by the SEC against Ripple and the XRP coin. If you don't know what Ripple is and you don't know what XRP is, I would suggest you not watch on because you're probably going to be bored to death. But if you do know what Ripple is, if you do know what XRP is, or even if you are a owner of XRP coins, watch on because we're going to be talking about what the lawsuit was all about from a legal perspective, and then God willing, we are going to take a little bit of a deeper dive into what is going on behind the scenes in this lawsuit right after the break. Okay, so you've made it past the break, so you must be interested in this, as I am. And as you know, the SEC recently filed a lawsuit against Ripple, alleging that the XRP coin or token is a security and was sold illegally as it was not registered with the SEC. And that's just kind of a very brief overall synopsis. But this, of course, caused the price of the XRP coin to tumble, and even some exchanges, many exchanges actually, to stop selling it. So the legal question, is it a security or is it not? The seminal case on what a security is the SEC v. Howey Corporation case from 1946, and it provides a four-part test for what a security is. Okay, now, in order to understand what's going on, you have to understand the legal ideas that are behind the lawsuit, and that is whether it is a security or is it actually a currency. So the SEC was created in 1934 to protect investors from fraud and tricksters, and you might see that the timing of the start of the SEC was right after 1929 when the stock market crashed. That's when there was a lot of fraud and tricking of investors going on. The Howey case involved the sale of an orange grove in a small town just 15 minutes north of where I happen to live in Florida. And what happened was the company got kind of creative with how it was selling its land. It sold half of its land to various individuals and then had the purchasers lease it back to the company. The purchasers didn't actually do or know anything about running orange groves, and actually none of them even really ever moved to Florida. In other words, the purchasers were completely reliant on the company for running the groves and making profits. And that point is extremely important. The court held that the land purchases were really investment contracts for the reasons I just told you. They weren't really running the land. It was just a scheme to kind of get investment in without calling it an investment. So the court saw through the artifice in the Howey case and said that these land purchases were actually investment contracts. Now, the black letter law that came from the Howey case gives us a four-point test whether something is a security, and this is what's going to be applied in the Ripple case. First, whether there was an investment contract. Second, the formation of a common enterprise, whether that existed. Third, whether a third party is used to promote the offerings to the public. There is the fourth test, but we're not going to go into that because really the Ripple case is going to depend on the first three prongs of the test. So now that you know the facts of the Howey case and what happened, you can kind of see where the courts are coming from on this test. They're not going to just look at what happened in the contract and whether you call it a currency. They're not going to look at whether it was really a land purchase. They're going to look at some of the things going on behind the scenes. Now, Ripple has hired some really top-notch lawyers. They're going to spend millions defending this. And in its Wells response, Ripple addresses all four prongs of the test, but really it's the first prong that's the most important, whether there was an investment contract. Now, Ripple's response to the first prong is actually fairly simple and eloquent, that there was no investment contract because there was never a contract between anyone. Ripple had no contracts with anyone, at least not maybe in the beginning, but definitely not later in the corporate life of Ripple. So the response is very artfully worded, but reading between the lines of the response, I think Ripple will probably admit that there were some contractual relationships, at least early on. Also, the large amount of XRP held by Ripple will be difficult to explain, and that's something that they're going to have to work around in their more formal response. Now, to the second prong, whether there was a common enterprise, Ripple has a more difficult argument because there was apparently some pooling of XRP, not just the type that satisfies the law. Third, was there a promise of profit by the issuer? Ripple argues that there was absolutely not, and any such promises and all corporate messaging of Ripple talked only about making XRP a better payment solution and didn't ever talk about just increasing the price of the coin. So that seems a winning argument for Ripple. And finally, was a third party used to promote the sale? I think Ripple will win on this prong of the test, mainly because this prong is really kind of antiquated and it's not something that Ripple would have done nowadays to hire someone. This is something that used to take place back in the olden days, like in the 90s. So now that you know what the law is, and these are the issues that the court's going to focus on, here's the important thing that you need to understand. The law is simple. You can learn the law like I just told you in a couple of minutes. There's 4 prongs, really 3 prongs of the test, and it's really simple to learn. But these cases and really all legal cases are determined by the facts as developed in the record. The prosecutors in this case, and in this case the SEC, will try and find facts which show that the sale of XRP was not like a sale of a commodity or currency, but was more like a sale of a common stock of a company, and that Ripple took the proceeds of sales and used them to increase the price of XRP for the common good. Now, will the SEC succeed? I don't know. They don't know, because they don't know what facts are out there. No one knows what the testimony will be. No one knows what emails will pop up, what agreements were made back in the day. I mean, even probably the owners of Ripple don't know all of the facts that will come out. There's text messages and phone calls and testimony. But what I can tell you from my brief review of the lawsuit and the Ripple Wells submission is that the SEC is fighting an uphill battle on this one. They do have the burden of proof, even though it's only beyond the preponderance of the evidence burden. And well, they better find a smoking gun out there. That's all I can say. Now, on their side, the SEC has almost limitless money to look under every stone. And while the case is pending, Ripple and its owners are stuck in legal limbo, money being drained from bank accounts and the focus of things other than their business on their mind. And that's not a fun place to be. And the SEC will absolutely use that leverage the best they can. Now, that is the legal case. And that's really, believe it or not, the superficial issue here. You have to dig a little deeper. The second, deeper, more important thing to remember is that very few of these, or any lawsuits, really go to trial. Most settle. This is true in every area of the law. So the SEC alleges every fact it can, even if it only has a remote possibility of making the facts stick, and XRP does the same. Currently, and in the next few months, what you will see is jockeying for position in the litigation, each side trying to position itself more favorably for a settlement or resolution of some sort short of trial. Try saying that 3 times. So what will a settlement look like? Ripple would almost certainly not admit to any guilt, because that would just lead to all sorts of private lawsuits and hell to pay. So there will likely only be monetary fines paid by Ripple, and probably maybe mandates to change certain business practices to make it more in line with the sale of currency and not a commodity. Now, that's just an educated guess on my part from 20 years of experience. So litigating yourself into position for a good settlement or resolution is the deeper dive. But then there is an even deeper dive. Cryptocurrency, blockchain, they are all new technologies. They are all very high profile. The law in America moves very slow. And even after almost 10 years, there is not much guidance on how to approach them. The head of the SEC up to December 23rd was Jay Clayton, and he had the Ripple lawsuit filed right before he left office, the day before. Interesting timing, Mr. Clayton, and I see a lot of conspiracy theories popping up online about it. Remember that Clayton had filed successful lawsuits against 2 cryptocurrencies before these cases back in 2009, I think they resolved. But those cases had not provided much guidance for the likes of Ripple or Ethereum or the other cryptocurrencies, because they were really the low-hanging fruit, the ones that were pretty obviously not doing things they were doing things the right way, but they needed to have SEC guidance. So the 2 cryptos that were, more obviously treating their currencies like securities. So there wasn't a lot of precedent that came from that. So from a non-cynical viewpoint, I could be cynical too if necessary, but this last move by Clayton was an attempt, from a non-cynical point of view, to set in motion the process by which our court system creates controlling authority and guidance in new and evolving areas of law, such as cryptocurrencies. Unfortunately, who suffers? The holders of XRP and Ripple itself, who in a sense are being used in order to create law and order for those that come after them. Now, don't cry too much though, Ripple. This is how our legal system works. And at the end of the day, this is a money issue and not a go to jail issue for anyone, probably. So you are in much better position than some of my clients. Now, the even deeper dive into the issue goes into politics, and there's even some deeper issues that we have to talk about, including the new Biden-nominated head of the SEC might want to switch sides, maybe placate the chain block investors group. I wouldn't be surprised if this happens, as this is the new internet. And does Biden really want all that money, knowledge, brain power moving to Singapore? I don't think so. But that's outside of my specialty, so I can't go that deep. There is one other deeper dive I will leave you with, and I can't really get into it too much because as a lawyer, we have ethical duties, should I say, or things that we can't say. But I will just leave you with the crypto industry is in its infancy, and all the companies and the coins are postured and were meant to be currencies. The use cases have not come to fruition in many cases, and so the coin values fluctuate too much. So although designed to be a currency, XRP, just for example, is being bought and sold like a speculation by users right now. So Ripple designed a rubber duck to be used in the bathtub, but everyone's taking that duck out to go hunting with it and using it as a decoy. So it's no one's fault that that's happening, but that is certain to draw the wrong kind of attention from the powers that be. And now it's a position where a judge might be forced to decide whether it really was made to be used as a bath toy and only a bath toy. So this should change as the stated uses come to fruition and currency values become less volatile. But anyway, our deep dive, has taken us to the bottom of the pool, so to speak, and I have nowhere else to go. So thank you for watching, and please subscribe if you watched this long.